So what is premarital property? This question comes up, this idea of what's property acquired during the marriage, what's premarital property, and how is it treated, what can I expect to happen in a divorce with these different categories for property. So, I'm attorney Brent Boyer, I'm from Adam. Don't forget to subscribe to the channel and like the video, that'll help us out. And why not? Like the video, maybe all your dreams will come true. You never know. So, premarital property, marital property. So Michigan is what's called a dual property state. Dual meaning two, there's two categories. We are not a community property state. So dual property, we look at, all right, what property was acquired during the marriage? That's called marital property. And what is separate property, or in this case, what's premarital property? So let's say I owned a house before the marriage, and then I've been married for 15 years and we still own the same house. And then there's this issue in the divorce of, well, that was my premarital property, so I should get that house, or all of that should belong to me. So with houses, they're a little more complicated than other assets because you live there, you do the upkeep, you pay the taxes, you pay the utilities. There's no way to just have a house that you had from before the marriage sit there and be untouched and no money goes into it and nothing happens. So they're a little more complicated, but let's say you had a retirement account. So you've been married 15 years, you had this 401k, and you had, $20,000 in the 401k at the time you got married, and now you got $70,000. So it's gone up 50 grand during the marriage, but you had that 20 at the time you got married, and you have statements that can prove that, or your wife agrees to that scenario. Let's say she agrees that those are the facts. So if you got 20,000 premarital in your 401k, now there's 70, you would have a valid argument to say, well, I should get the first 20, really plus any gains from that 20 during the marriage, because that was just passive increase. That was just market increase. You weren't actively managing your 401k. Most people are not actively managing their investments in their 401k. They have somebody doing that for them. So you're contributing to it and it's going up in value over time, but you can still segregate out, I had this 20 grand, that's my premarital portion of the 401k. Now it's 70. So we should be splitting the 50 when we get divorced and not the whole 70. So that would mean I would get 20 and then I would get half of the 50. So I'd end up with 45 instead of just getting my half of the 70, which would be 35. So it gives you a little bit of an advantage. Or if you had a premarital retirement account from before the marriage and you still have that whole account, let's say you had an IRA that you're not contributing to anymore, you would have a claim that you can keep that entire IRA at the time of your divorce, even if it may have gone up in value during the marriage, again, because that's just market increase, it's passive increase. So that's some examples of this whole concept of premarital property versus marital property, this dual property analysis. Of course, if there's a prenuptial agreement, that certainly strengthens your argument. But even without a prenup, you would have a valid claim that anything you had before the marriage, houses, cars, retirement, savings, investment, whatever it is, if it's still there now in some form, you have a valid argument. There's a narrative where you could say, well, this part was mine and here's why, and here was kind of the whole story. And it gives you an advantage instead of just everything's half and half no matter what. So hopefully that helps.